That's a wonderful welcome, everybody. Let me turn to Sappho. I'm Mary Caldwell. Let me turn to Sappho to say a few words.
As we say in Burma, Mingalava, ladies and gentlemen, it gives me great pleasure on behalf of the London School of Economics and of the Burma Justice Committee to welcome the panelists and you to this event with a great heroine of our times who really needs no introduction. She exemplifies all that is best, not just about Burma, but also about humanity itself. She has used her life to better the lives of others, and she has done it at great cost to herself. In a famous call to the outside world, which has resonated throughout it, Daw Aung San Suu Kyi once asked all of us to use our freedom to help secure freedom in Burma. And more recently, after emerging from long years of house arrest, she called for help in restoring the rule of law. At the Burma Justice Committee, what we have done, apart from calling for the restoration of the rule of law, is to use the law to help political prisoners with cases to the United Nations Working Group on Arbitrary Detention. But amongst our number are many eminent QCs who have gone to regions blighted by conflict to help in programs of training and education of both lawyers and judges, and to put in place an idea of the primacy of law, the idea that the law is king. In a world in which there is so little security, in some senses, what has happened in Burma so far is promising. An internationally respected leader who has been released and who has been permitted to come and speak to us about what assistance we can give her in the great task of nation building which lies ahead of her. We are very honored that lawyers and the law has been one of the first ports of call of this courageous and great lady. Welcome to this round table talk with our distinguished panelists and with Daw Aung San Suu Kyi. And I hand over to
Well, I can hear from all your claps, there's such enthusiasm in the audience. This event, at Daw Suu's request, is about the rule of law, but I know everybody wants to ask her questions. So we're going to have a very short beginning part with our speakers talking about the rule of law, and I will ask them questions very briefly, and I will ask some questions that have been pre-submitted by people. Unfortunately, we have no idea whether the people who submitted the questions are in the audience or not, so I will read the questions. And I'm going to start with Nikki Lacey, who, as most people at LSE will know, is one of the great scholars of the rule of law, and ask her to explain how understanding the difference between procedures and substance of the rule of law can be useful for a country like Burma.
Thank you, Mary. In the literature on the rule of law, a distinction is often drawn between procedure and substance, and indeed, I think until recently, much of the scholarship on the rule of law saw it as essentially a procedural conception. So that ideas like the equality before the law, the independence and impartiality of the judiciary, the idea that laws must be accessible, intelligible, clear and predictable, these are essentially procedural values. And of course, therefore, consistent with substantively unjust laws. But more recently, I'm thinking here particularly of a book published just before he died by Lord Bingham. I think we've moved more in the literature towards an idea that the rule of law also encompasses respect for human rights, the aspiration to treat people as persons with dignity, and indeed that it could also encompass compliance by the state with international law obligations. And then a third position, would be that we should think about the rule of law as essentially a procedural conception, but that nonetheless the discipline of subjecting power to those procedural constraints itself may build in a tendency towards more substantively just law, or indeed have its own distinctive value. Now, for various reasons, perhaps for obvious reasons, it's often thought that the procedural conception of the rule of law is of more relevance for countries in transition to democracy, its formal nature making it more widely applicable. And there's a certain intuitive sense in that, I think. But in my view, it can very easily be exaggerated for two reasons. First, even procedural or formal standards embody values and assumptions of substance. Second, in a sense, it's those underlying values, the ideals of respect for persons, which make the rule of law such an important part of the progressive political rhetoric of which you have been such an eloquent exponent. So I'd like to suggest it might be more useful to work with a slightly different set of distinctions. First of all, thinking about the rule of law at a very abstract level as a potent symbol on which people with vastly different experiences can identify, and which can therefore be highly effective in both motivating political action and solidarity, and because of the global reach of these ideas in helping to build transnational alliances. At the second level, slightly more concrete, we could think of the rule of law in terms of the standards and understandings and values and norms which have gradually developed in international understandings, including in international law. And thirdly, and perhaps most crucially at the moment in Burma, would be our understanding of what the rule of law requires in the specific economic, political, and cultural circumstances of a particular country at a particular time. This is the really hard question. How do we design a rule of law appropriate to particular circumstances while still hanging on to the universality of the ideal? And that, I think, inevitably brings us to the question of institution building.
And there was a question, actually, you've rather touched on it, but I don't know if you want to add to that, from Dan Squires of Matrix Chambers, who asked, how can Burma learn from other countries' experiences in re-establishing the rule of law? Are there any examples we could learn from?
I think that really does take us to institution building, doesn't it? And I think here, just one example I'd like to throw in, which would be the example of South Africa. It seems to me that the analogies between the position in Burma and in South Africa are quite interesting, and that South Africa offers a rather positive model for post-transition rule of law. And it's worth thinking about why that is. And first of all, I think that the key factors here are that in South Africa it was a peaceful transition, and reformist aspirations were very widely diffused across the population. And then in terms of process, the move to a democracy was attended by a very wide consultation, which crucially, and again very relevant to Burma, involved all groups thinking about, all ethnic groups thinking about what would look like the right sort of constitution for post-apartheid South Africa. So if we think of what they came up with, there's a tremendous amount of institutional innovation in South Africa, it seems to me. Not just obvious things like the Truth and Reconciliation Commission, which I know you've spoken about, but also thinking about the constitution of the Constitutional Court in both symbolic and material ways, such that they've produced, it seems to me, a sort of structure, an institutional structure for the rule of law, which is quite distinctive to and appropriate to post-apartheid South Africa. So I think that's a sort of bottom-up transition, which suggests that a rule of law sort of worth the name is a rule of law that has to be located within institutional arrangements with a real capacity to constrain power, and that means being really firmly rooted in the broader social structure. I think, just as a footnote, it's also worth remembering that the rule of law is always a work in progress, isn't it? There is no perfect compliance with the rule of law. Every country is always working, if it's a civilized and progressive country, on improving its compliance with the rule of law. So.
Oh, thank you. Whenever you want to come in, you're free to do so. But I was going to move to Geoffrey Nice.
I'll listen first.
I'm going to move to Geoffrey Nice because, in a way, that's a very good transition. And I want to ask him about, and particularly given the example of South Africa, how important is transitional justice for a substantive transition to the rule of law, and what form might this take in Burma?
Methods of transitional justice are varied, from retributive trials through peace commissions, reparation, lustration, memorialization, and so on. Each has its own supporters. None of them have very predictable results. Not surprising, they're all comparatively recent exercises. Anecdotal evidence might suggest that retributive trials of the kind tried in the ad hoc tribunals for Yugoslavia and Rwanda, and also made possible at the International Criminal Court, are not very successful, if successful at all, in the wider purposes of bringing about reconciliation. Other experience may suggest that peace commissions work best when in combination with other processes, but overall uncertain in their effect. Thus, if a leader decides to change with his past and make the rule of law available, should he be allowed to do that without coming to terms with the past? Can he do that? Theoretically, yes. In practice, no. Yesterday, at an informal tribunal established by the diaspora of Iran to deal here in London with the mass executions of political prisoners in the 1980s, a welcoming address was sent by Archbishop Desmond Tutu, and he explained that the passage of time is rarely or never enough, that something else has to be done. And those of us, all of us, whether from speaking with the victims of conflict, or whether speaking to people who have suffered personal injustice, or even having been the cause of injustice ourselves, know that whatever may be the preferred result of the person who has suffered, retribution, vengeance sometimes, or some other solution, he or she will always want to know what happened, how it happened, why it happened. He or she would, of course, prefer the person who was responsible to acknowledge responsibility and even to apologize, for that is finally, or at least it's the best step on the way to the night of peaceful sleep that all are entitled to, including those who suffer in conflict. And perpetrators know, of course, that they must acknowledge what they have done. Sometimes it is fear that stops them doing it, a topic on which I know that you have, I think, yourself spoken. Albert Speer, Hitler's favored domestic architect, was tried at Nuremberg, convicted, but he escaped the gallows, and thus afterwards, when writing of those events in which he had been involved, likening them to other horrifying events like the genocide of the Native Americans, said that everyone gets involved, almost everyone, and then when it's over, says to himself or herself, good heavens, how on earth could I have done that? And it is but a small step from that recognition to the next stage of acknowledgement or apology those who suffer most seek. And so in passing from one state to a state where the rule of law is honoured, the past cannot be overlooked and has to be dealt with. But to the second part of the question, what can be proposed for Burma? That's a very difficult question. And those of us who may have been involved in earlier years in making proposals and trying for certain solutions must now recognize that this is entirely a matter for the people of the country concerned. It has to be their choice, not just because as individuals they will want to know what happened to them, what happened to their loved ones. Like the witnesses in the informal tribunal yesterday, a top concern being wanting to know where their loved ones were buried so that they can mourn them as a minimum. But the combination of the collective knowledge becomes the history, or at least one part or one narrative of the history of the people concerned. And it is to achieve that, amongst other things, that there has to be a transition process. Whether through retributive courts, I personally doubt. Whether when the time is right, through a process of a commission, I would personally prefer. And my last observation is this: even if at present the prospect of a transition which can deal with the past may seem difficult or even remote, we should all have in mind that the modern age has handed over from national and international bodies that may favour or disfavour processes of transition. It's handed over a lot of power to the individual, who in the modern information age is far more powerful than he or she ever was, both to deal with, in transition, the process of his own and indeed the process of the collective memory.
Thank you very much. And I'm now going to turn to Professor Christine Chinkin and to ask her about respect for human rights, which is, as Nikki told us, such an important part of the substantive rule of law. How can compliance with the international human rights regime be fostered? And in particular, what issues need to be addressed to ensure the rule of law is relevant for women?
Thank you, Mary. And as you have just said, and as Nikki referred to, human rights are, of course, part of the sort of substantive values that the international community today embraces and sees as a major starting point. But compliance with human rights is always, I think, for any government, at the end of the day, a matter of political will. And I know there have been discussions recently, it's a matter of considerable debate, whether compliance is better fostered through promises, easing of sanctions, for example, or through threats. The threat of further sanctions imposition if there isn't continued reform. Those are decisions for political organs, political institutions. So I was going to also suggest that the legal framework of the UN human rights mechanisms, while they have no formal sanctioning power, nevertheless do have a role to play in fostering an overall environment for human rights compliance. Just to mention a couple of procedures of the UN human rights mechanisms. First, Burma, of course, has a very limited record of ratification of human rights treaties. But nevertheless, the Universal Periodic Review process before the UN Human Rights Council is applicable to all states. Burma has indeed participated in it. We're now coming to the second round of that process. And it seems to me that if the members of the UN Human Rights Council, who will be assessing and monitoring the review given by the government, if they are prepared to ask hard questions, if they will challenge the government on issues like its insidious denial of human rights violations that took place in the first round of the universal peer review process, if they will ask for details about what has happened since, insist upon recommendations being taken seriously, this could indeed be something rather more than just a ritualistic type process. Another possibility, and one that would again depend upon the will of the international community, is a commission of inquiry. Now, not in the sense that was just talked about, but rather in the sense of providing an independent mission looking at what has occurred, providing at least some record with respect to possible commission of war crimes and crimes against humanity, that would make denial and obfuscation that much harder, and would also provide some basis for further action which, as has been said, must be from within rather than externally. And a third possibility is that the international community, through the Office of the High Commissioner, has seen national human rights institutions as an important bridge between the international and the national. There has been a National Human Rights Commission created in Burma. It's been very much criticised, I understand, for its lack of independence, for its weak mandate, for its unwillingness to take a proactive investigatory role. But again, if there was greater pressure put on this body to take seriously its role as a human rights promotion body, if it received technical assistance and I think the importance of external support, that might as well act as some body that could work to foster a human rights environment. Clearly, they are all flawed processes. Clearly, no one issue is going to be effective, but there are a range that can be taken. And what we need, I think, is long-term commitment, drawing on everything that is available in the international community, and again, as has been emphasised, working very much from within to see what are the priorities, what people within the country see as the best leverage points to work with. The international community can at least give some support. Women. Women in the situation of the rule of law, a great deal, but one could say. I just stick to one sort of very short point, which is that in reform of judicial institutions that is associated with the reform of the rule of law, it is important that there is secure, ready access to justice for women who are seeking accountability, particularly with respect to the crimes of sexual violence that are being committed against them. The current impunity that is enjoyed by military, police, security officers inhibits investigation, it prevents prosecution, it undermines any chance of reparation in the broadest sense of the word, and contributes, I think, to a cycle of violence which very much undermines the rule of law. Now, clearly, women as well as men have endured a whole range of human rights violations. Sexual violence is only one of multiple human rights violations that have occurred. But it has been said, indeed by yourself, I believe, that it has been used, sexual violence has been used as an instrument of intimidation and division. It's been deliberately targeted, particularly in the context of ethnic minorities. And lack of any accountability for these crimes, I think, serves to normalise violence. It continues then in what might be called a post-conflict or a transitional situation, and weakens any real transition to democracy in which the entire population can participate.
That's really important. Now I'm going to ask you one very quick question, because we're run out of time, from Brian Sanderson, a governor of LSE. Some years ago, I was managing director of BP, responsible for Asia. We had to decide whether to do business with the military regime and publicly open an office and invest, or to take a stance on human rights issues in general and forced labor in particular, and refuse to give the regime credibility. What should we have done, in your view?
In 1 minute or
1 minute,
even
yeah.
less. A question that raises huge, of course, issues that are pragmatic, legal, and ethical. Rather than look at the past, I think I might just refer very briefly to the fact that this is an area where there's been a great deal of thinking within the international community, notably the work of John Ruggie with respect to business and human rights, who has been seeking to develop tougher standards for corporations, giving them the questions that they should ask before making decisions of that sort. And Ruggie has emphasised that alongside the obligation on the state to protect human rights, which of course the state was failing to do, there is a separate and independent obligation on corporations to respect human rights, irrespective of the national situation. And this requires the company to ask itself questions about the impact of its activities on human rights in the area, to have an obligation of due diligence to identify, prevent, mitigate, and account for how they, the company, address the impact of actions on human rights within the area in question, even though the abuses may be being committed by others. So that requires, I think, a long, hard, honest look by corporations to look at the context of the proposed actions, look at the likely impact on the authorities, look at the likely impact on the people, notably minorities, displaced persons, which are very often the situation. Might also add, of course, that they might take into account the potential for legal action, depending on knowledge, constructive knowledge, level of activities, with respect to complicity, even complicity in war crimes. And then, of course, there's also moral complicity, which I think flows from implicitly, at least, supporting the acts of the government. But I'd say no.
Well, finally, we have Zani, who's a visiting fellow at the Civil Society and Human Security Research Unit, which I direct. And I'm going to put directly to him some questions which were actually put to Dorsu, but I'm going to put the pre-submitted questions to him. And the first one is from Amal de Chichera of the Equal Rights Trust. Stateless people around the world require the protection of their home countries and of the international community in order to live secure and dignified lives.